there are two things I want to just point out from these decisions. And it's unclear to me at this point how much Alito's brief tracks with what came out. I believe at first blush, the main difference is that the language that Alito had put in about those cases that Jamal Bowie mentioned, Griswold, which has to do with birth control. This was a case, I believe, in the 50s, maybe it was this early 60s, where the court found a right to privacy involving people taking birth control. Lawrence was a case out of Texas. I believe this was in the aughts, that there was a law on the books in Texas that you could not, Griswold was 65. Lawrence was 2003. Thank you. You could not engage in anal sex, or I think in some instances also oral sex. And this struck that down. Obergefell, of course, was the case that the Supreme Court found a right to marriage equality. So Thomas writes in his concurring opinion, these were mentioned in the Alito brief. And do we have a tear sheet of this? Is this number? No, it doesn't. Okay, we'll get to that in a second. But Alito, Thomas says in future cases, we should reconsider all of these courts' substantive due process precedents. That is, out of due process comes these rulings. They are founded in that. The 14th Amendment, also we mentioned Loving v. Virginia, is also one that came out of that. He didn't mention it. Loving v. Virginia is, of course, the thing that makes it, here we go. And it is unclear. Originally, Alito had it in his brief, and I suspect, to the extent that there was any change, it was, Thomas, you're going to have to do this on your own. We're not going to put it into the main brief. But let's be clear, folks. This is going to be cited. I promise you. I promise you. I don't know if it's going to happen next year or in 2 years or in 3 years. But over the next year to 3 years, you are going to see some circuit, maybe it's the Fifth Circuit, maybe it's some other circuit, where there is a majority of Republican-appointed federal judges. They are going to rule on the question of Griswold, on the question of Lawrence, on the question of Obergefell, maybe even Loving v. Virginia. And they're going to rule in a way that chips away, if not reverses or attempts to reverse these. And maybe the circuit court won't reverse it because of precedent, but this Thomas brief will be cited. And these precedents will be tested. And there is no reason to believe that marriage equality, the marriage equality precedent, is any more robust than a precedent that has existed in this country for about a quarter of its existence. Maybe, I guess, a fifth of its existence. This court does not care about precedent. Here is Samuel Alito writing, there is no right to an abortion in the Constitution. The Constitution does not afford people a right to any type of biological or physiological, pop this up, freedom, as it were. You have this? This is clip number 1, right? Here it is. The Constitution does not confer a right to an abortion. Roe and Casey are overruled. and the authority to regulate abortion is returned to the people and their elected representatives. Even though we know in many of these states, at the very least, minoritarian rule. There was a joint dissenting opinion, Breyer, Sotomayor, and Kagan, and this is what they wrote here. Put this up. It starts, there was no support, because at one point, you know, the question that Alito is saying is there support for, is there, you know, we cannot find any type of right that did not exist at the time of our founding. You know, these are rights that just came up in the 20th century. It is an absurd perspective on this. But they're talking about, they're bringing this up. Lawrence v. Texas, Obergefell, they're writing, these are all part of the same constitutional fabric, protecting autonomous decision-making over the most personal of life decisions. The majority, or to be more accurate, most of it, is eager to tell us today that nothing it does, quote, cast doubt on precedents that do not concern abortion. Now, to be clear, Thomas, again, wrote, advocated, and they mentioned it's the overruling of Griswold, Lawrence, and Obergefell. But just because the Supreme Court, the opinion says, now keep that up, please. Just because the opinion says that today's ruling does nothing, does cast doubt on precedents that do not concern abortion, doesn't mean that today's ruling does not cast doubt on precedents that do not concern abortion. Remember, the Bush v. Gore, they argued, this has no precedence. Do not cite this case. Never talk about it again. This is a one-off. But the fact is that it's been cited over and over and over in election cases. And this one will be too. In fact, they write, but how could that be? How could it be that this does not cast doubt on precedents that are outside of abortion? How could that be? The lone rationale for what the majority does today is that the right to elect an abortion is not, quote, deeply rooted in history, end quote. Not until Roe, the majority argues, did people think abortion fell within the Constitution's guarantee of liberty. The same could be said, though, of most of the rights the majority claims it is not tampering with. The majority could write just as long an opinion showing, for example, that until the mid-20th century, quote, there was no support in American law for constitutional right to obtain, in parens, contraceptives. So one of two things must be true. Either the majority does not really believe in its own reasoning, or if it does, all rights that have no history stretching back to the mid-19th century are insecure. Either the mass of the majority's opinion is hypocrisy, or additional constitutional rights are under threat. It is one or the other. That is the most important part of that dissent. And it is ironclad. Either it is important that these rights, that any rights that are found in the Constitution explicitly existed in the 18th century or in the 19th century, or they're not good today. Now, of course, this does not apply to the Second Amendment, which was not a personal right until 2008 in this country. Leave your guns outside of Dodge City. I mean, there were permitting process, there were gun restrictions in California in the 60s. I mean, there was no individual right to carry arms that was unencumbered by the state until 2008 in this country. Yet they just had the audacity to write an opinion that says there was no right to abortion until 1973. I mean, people have to understand that this court is bullshit. And I think, what's his face? Who's that guy who defended Nestle's...
Neil Katyal.
Yeah, Katyal, yeah.
Neil Katyal wrote some comment to the thing, sort of funny that they...
very weird.
Very weird. Yeah, very weird. Grow up. I mean, actually, that's the wrong admonition because he knows. He's just trying to make sure that he maintains a relationship with the Supreme Court. But don't say anything publicly then, because it's damaging to the body politic when you diminish this level of hypocrisy. It's damaging. You should shut up. You want to protect your ability to be a solicitor in front of the Supreme Court? God bless. Shut up in public. Don't tweet. Don't go on CNN or MSNBC and spread your BS. If you have nothing truthful and insightful to say nothing at all. I mean, really, people need to be held to account. They really do. And then folks need to understand that all of this stuff that we're seeing in terms of individual rights is also happening with far less glitz and gleam and shine in terms of government's ability to protect workers, to protect citizens, to protect our air, to protect our environment, to protect our food, our water, to protect our financial systems, to protect people's homes. I mean, on and on and on. The assault is going to continue. And we don't have a lot of tools to stop it. Electoralism is not nearly sufficient, but it is absolutely necessary. Come at me and tell me again about the value of your vote for some third-party candidate and why it was a joke to vote based upon the Supreme Court. People need to educate themselves. It doesn't matter what policy you're in favor of. It doesn't matter. With a court like this, both houses and the president, although Biden said he wouldn't, could sign Medicare for all tomorrow. And it would be struck down by this time next year, before it even got implemented. And if you think otherwise, that's insane. That's insane. Honestly, it's insane to think otherwise. They couldn't even get Medicaid to be expanded with this court. And that was a position that was a compromise position that John Roberts got thrown under the bus in the pages of the Wall Street Journal before. And why he lost this round when it came to Roe v. Wade. That's the bottom line. It is depressing. I'm not going to lie. Because to the extent that there has been a singular mission on this program when it comes to any particular issues, it was, try and add a level of sophistication to people's understanding of the courts and their importance. And this is just it could very well be the most egregious thing that the court does, just in terms of you've rolled back a 50-year precedent, but also it is the first time in this country we have ever rolled back an individual right. And less academically, it's going to cost lives. It's going to immiserate hundreds of thousands of people. It's going to increase child poverty. It's going to, it's going to inhibit the lives of millions of women, millions and millions of women. It's also sending a message that we have two classes of citizens in this country. The ones that have some autonomy over their body and the ones that don't. But there will be a whole host of things that are going to fundamentally impact your daily lives. We will see it. More people we will have climate change will come maybe a little quicker, a little harsher, maybe because we have no mechanisms to mitigate it. You will maybe, I don't know what the numbers are. How many people know somebody who dies of food poisoning, who dies of cancer or have asthma? But those numbers will go up. You'll know more of those people over time. It just goes on and on. All right. I'm in. And I think the best thing that we can hope out of this is that it lights a fire under people and it motivates people to change Democratic leadership and to have them and to figure out how to change leadership, change the nature of the party, but also still prevent Republicans from coming in and doing more damage, because they will. And also, people have got to focus on helping those people around them. If you want to donate money, look for a local organization, state organization that is going to help women get abortion services. There's going to be 26 states in this country where it's going to be banned. And like I say, don't tell me about exceptions. That's irrelevant, because those exceptions will not create abortion opportunities even for those people, because a ban like this, where things are criminalized, and they will be criminalized in every state, I promise you, will inhibit healthcare providers from providing health services to women. Period. End of story. That's just the reality. That is just the reality. So find local organizations. You will hear from them. Support them. Get involved. It's going to take a lot of people helping. And again, I would not be surprised if we see a federal ban by 2026.